Hello, class. So in this slideshow, I'll be giving you a brief overview of Michelle Alexander's book, The New Jim Crow, and highlighting some of the major themes in the chapters. So she argues that what we are experiencing today and have been experiencing over the last, 4 or 5 decades of draconian enforcement of drug laws is a new system of racial control that she calls the New Jim Crow. So after slavery, as most of you are aware, there was a system of racial oppression known as Jim Crow. And this lasted approximately from 1876 to 1964. And this included housing segregation, poll taxes, literacy tests, and many whites-only venues, perhaps most popularized by white and colored drinking fountains, although that is the least of the problems probably created by this racist regime. It nonetheless sticks out in our mind. And then, of course, you have the violent shock troops of the Jim Crow regime, the Ku Klux Klan, who are domestic terrorists. There is legal precedent that set up this whole system. That's Plessy v. Ferguson, 1896, that declared separate but equal for venues separating whites and blacks and institutions, including schools and churches and about everything else in between. So it's not just a cultural phenomenon. There was legal enforcement of Jim Crow, starting with Plessy v. Ferguson. We get to the mid part of the 20th century, and this is where the Jim Crow regime begins to become challenged in the courts, most famously with Brown v. Board of Education of Topeka, Kansas in 1954, which overturned Plessy v. Ferguson. And then it was quickly followed up by the Civil Rights Act of 1964, as well as the Voting Rights Act of 1965, which these collectively said that states and the federal government cannot discriminate in business practices, voting, or public service on the basis of race, gender, or religion, essentially applying the 14th and 15th Amendments to states and the federal government more broadly. This did not sit well with some of the population in the United States, and so skillful demagogues in Washington took advantage of this, noting that many Democrat voters in the South were not okay with these changes, and so Nixon was one of the first. It's really just historical accident that Nixon happened to be in the Republican Party and that he kicked off this new system of racial control as Michelle Alexander describes it, because as we will see later, the Democrats got in on this just as well. So with Nixon, though, you have what is known as the Southern Strategy starting in 1968, and the whole point was to unite Southern rural whites with some working class whites in northern cities to rail against what they thought was undermining the American way of life, which involved a big dose of Jim Crow regime. And there is some pretty damning evidence that part of the Southern strategy was to pit working class whites against blacks in a conversation that took place supposedly between one of Nixon's closest advisors, H.R. Haldeman, and Nixon. It was claimed that Nixon said, "You have to face the fact that the whole problem is really the blacks. The key is to devise a system that recognizes this while not appearing to." So this is what Michelle Alexander means, or one example of what Michelle Alexander means by a system of racial control in an age of color blindness, that it is still a racist system even though it appears as it is not. And that's the key there, that you don't need to have violent terrorist domestic thugs like Ku Klux Klan in your face to have a racist system. It's much more subtle, more pernicious today than what it had been in the past. And in 1968, we see a Gallup poll that reports that 81% of respondents agreed that law and order had broken down in the United States. Violent crime was in fact increasing during the later part of the 1960s, as the graph on the right shows. And the majority in this poll, and this is telling, the majority in this poll blamed, quote, Negroes who start riots and communists. So you might find that sort of strange, lumping together blacks and communists, but you have to understand in the mid-1960s, they were both considered threats of a similar level of dangerousness. But what we want to recognize is that there was real concerns about violence rising in the United States. And so it wasn't as if people were hallucinating. There really were rising levels of violence in many cities throughout the United States, and people wanted something done about it. And so what you get following this is an increase in enforcement of criminal laws, particularly as we will see as they apply to drugs. And here's the first of many Supreme Court cases that Michelle Alexander points to as the beginning of the new Jim Crow, and that's Terry v. Ohio, 1968. This set up the so-called stop and frisk rule, where the court found that police may stop and search a person if reasonable articulable suspicion exists. And they can do this, and here's the key, without a warrant from the judge. So long as the police officer thinks that you are doing something that would suggest that you might have weapons on you or you might have drugs on you, they can search your person or your car without getting a warrant from a judge. And so, according to Michelle Alexander and many people on her side of this argument, this is the beginning of the official beginning, according to courts, of the new Jim Crow. And it is in the 1970s when we see the real war on drugs start to take shape, beginning in 1970 with the Controlled Substances Act, which placed marijuana along with many other psychedelic or hallucinogenic drugs on the federal government's Schedule I list, which means that there is, according to the federal government now, no recreational or medical use permitted. We know now this is probably not true at all for marijuana and may not be even true for many hallucinogenic drugs, as some people are now advocating for the use of MDMA for the treatment of PTSD among war vets. So the chart is on the right, and you can take a look at that. But despite the fact individual states have now legalized marijuana use, we still have this scheduling system where it is marijuana, in particular, the drug that people are most likely to be arrested for, is still considered to have no medical value, and there is no recreational use permitted, according to the federal government. So that's the beginning. And in 1971, Nixon declares a war on drugs. And shortly after this, the DEA, or Drug Enforcement Agency, is established in 1973, and this is the federal agency to police drug use and to enforce drug laws. And then we get to, skipping over a couple presidents here, getting to Reagan in 1982. Reagan redeclares a war on drugs. And in 1985, crack cocaine, the rocked up version of cocaine, appears in US cities. And it was devastating to many people of color in inner cities. And the mass media exploited this fact by jumping on any stories that reported on crack babies, crack dealers, crack whores, and welfare queens. And so while it is true that crack swept through a lot of majority black inner cities, like the Four Horsemen of the Apocalypse, the mass media jumped on this and made this public issue number one. And so now generally the public, in their mind, they are associating crack cocaine use with black people, even though whites were just as likely, if not more likely, to use the drug than blacks. In the 1980s, we see a series of policy changes that make drug enforcement a number one priority. So in 1984, you have the Comprehensive Crime Control Act, and this paved the way for civil forfeiture, forfeiture of property that was involved in drug crime. So a lot of times these are vehicles that are confiscated by the police, and they're allowed to keep them. So you see DARE vehicles driving around that have the DARE logo on them, and they're a cop car that was once a drug dealer's car. In 1986, you have the Anti-Drug Abuse Act, which established mandatory minimum sentences at the federal level. Many of these were then adopted at the state level as well. And so it made it much more likely for you to go to prison for a drug-related crime. And just to be clear, a lot of times this is not, the arresting offense is not drug possession. It's usually drug trafficking, and there may have been a gun on the person who was arrested. It gets plead down to possession for a shorter sentence through a plea bargaining process. And then 1988, you have the Anti-Drug Abuse Amendment Act, and this is what established the notorious crack cocaine sentencing disparity, that for whatever sentence you get for some amount of crack, you would have to have about 100 times more of the powder version of the drug in order to get the same sentence. And for many people on Michelle Alexander's side of the argument, this is clear evidence of racial discrimination, because who do you think is more likely to use the crack version of cocaine? Well, blacks are, because it's cheaper and more abundantly available in inner cities versus the powdered version that whites are more likely to use. And then in 1988 as well, you get the Byrne Federal Grant Program established, which funnels federal tax dollars to local police to help fight the war on drugs. So for local police, this is a no-brainer. It is just absolutely anathema for a lot of local governments to raise taxes on their citizens in order to fund fire departments, police departments, any municipality like that. And so what started happening in the late 1980s and continues on today, is that in order to make up for budget shortfalls, you have to enforce the drug laws. And if you do that, the federal government will pay you. And so you have this, it pays to play, as Michelle Alexander says it, regime set up, so that it is well within the interest of local police departments to enforce drug laws, because they are able then to get new equipment, get new police cars, give raises to their people, and without raising taxes on the local population. So again, it's kind of a no-brainer. And as the chart on the bottom right shows, these changes in drug policies had a disproportionate impact on blacks compared to whites. And I think I should just point out again that it's not as if blacks sell or use drugs at much higher rates than whites. There is a higher rates of homicide and homicide victimization among blacks for sure, but the rates of drug use and drug dealing, if anything, are higher among whites. Yet it is blacks that are more likely to be arrested. And so this is a point that Michelle Alexander makes several times in her book, that if we were talking about enforcement of just strictly violence, it may make sense that you would have higher rates of arrests and incarceration for violence among blacks, which you do. But it becomes much more problematic when you see these much higher rates of arrest for drugs among blacks. And this is something that liberals and conservatives both have concerns about, because it is, for conservatives, this is a clear example of big government run amok, that it's overreach, it's costing people a lot of money to enforce these laws, and for liberals, because it's has a disproportionate negative effect on blacks, this is just a real problem that we have to do something about. And then we get to Clinton. Clinton's administration in the 1990s played a major role in making the situation much worse. With the 1994 Violent Crime Control and Law Enforcement Act, which seems on its face to be all about violence, it also involved a lot of drug offenses. So this set up 3 strikes legislation, where you would get life in prison for 3 felony convictions. And the thing about this, while on its face it seems reasonable, but 3 separate felony offenses, you can be hit with this all in one single court appearance. 3 separate criminal acts in the same day, same incident. This can include drug offenses as well. Okay, so that was Clinton's contribution to making the situation far worse, at least according to Michelle Alexander. And now I'd like to highlight some of the court cases that Michelle Alexander discusses in her book that she argues are clear evidence that the war on drugs and the criminal justice system more broadly is a part of what she calls the new Jim Crow. So if we first look at McCleskey versus Kemp in 1987, McCleskey was a defendant who faced the death penalty in Georgia, and the Supreme Court rejected the defendant's case, which the defense cited studies showing that blacks are more likely to see the death penalty than whites, and this cannot prove racial bias, however, in individual cases, according to the Supreme Court. So it's not a violation of the 14th Amendment due process or the 8th Amendment protecting against cruel and unusual punishment. And what this did was set a legal precedent for numerous similar lower courts regarding decisions on racial bias. And if you look at the map on the right of the United States, as many of you are already aware, the states vary in whether or not they have the death penalty. So this kind of adds insult to injury, if you will, that if you happen to be in a state with the death penalty, all the worse for you if you were somebody who is against the death penalty based on principle alone. Now, the person may have committed a heinous murder, but if you think it's just as bad as if the state commits a premeditated murder in executing the person, then states, particularly in the South and some states out west, are not doing themselves any moral favors by enforcing the death penalty. And so that's another layer of ethical problems put on top of these court decisions that have a disproportionate negative impact on blacks. Several other cases here. Perkett versus Elm in 1995 said that race-neutral reasons for striking jurors is acceptable, even when a proxy for race is pretty clear. So you cannot, because of previous court cases, you cannot strike somebody from a jury simply because they're black or because they're of a race that you think may not vote in your favor. But things like hair type or style of dress, which, if you spent any time in the United States at all, you will recognize that hair type and style of dress often are closely correlated with someone's race or ethnic makeup, that you can be struck for those reasons. And so she points to this as an example of what looks to be colorblind really is part of this new Jim Crow system, that it's discrimination in the age of color blindness. So you can discriminate, but you have to appear as if you're not discriminating. Then you have Armstrong v. United States in 1996, where lawyers for the defense argued racial bias on account that there were no white defendants facing crack charges in the California federal court. But the Supreme Court ruled that the defense could not access the prosecutor's files from previous cases to show racial bias, saying that you cannot draw upon prior empirical evidence of racial bias in an individual court case, which for someone like me who's a social scientist whose whole professional career depends on the existence of lots of empirical evidence, this is really hard for me to understand why the court would not want this. And perhaps it's just it's going to introduce a lot of complications, a lot of statistics that people in the jury and the judges may not understand. But what they're essentially saying is you can't draw upon lots of data and apply it to any individual court case, particularly as it may apply to racial bias. And then we have Wren v. United States 1996, where this said that suspicion of racial bias cannot be used to challenge a criminal charge under the 14th Amendment. And so this closed the door to any cases challenging court decisions that may be perceived as having racial bias with the support of the 14th Amendment, saying someone's due process is being undermined because of racial bias from the jury, from lawyers, from the judge, etc. And now we get to Obama, which some voters naively may have thought that because Obama is black, that he is going to be doing about face on a lot of these drug laws that have had a disproportionate impact on blacks. And while he did make some changes to the crack cocaine sentencing disparities at the federal level, there were other problems that Michelle Alexander points to and other critics of Obama have pointed to, citing, for example, the Economic Reinvestment Act of 2009, which happened to include increasing funding to the Byrne Federal Grant Program, which I mentioned earlier is the way in which a lot of local police departments make up for budget shortfalls, is by enforcement of drug laws in order to get funds to avoid raising taxes on the local population. So that happened. So Obama administration is okay with that kind of thing going on. And also, the Obama administration spent a larger proportion of federal tax dollars on law enforcement for drug offenses than treatment and prevention, compared to that of George W. Bush. Just a reminder, Obama is supposed to be a liberal Democrat, where George Bush was a conservative Republican. Yet the conservative Republicans are spending more on treatment and prevention than a liberal Democrat administration. And also, if you look at the chart on the bottom right, this is asset forfeitures that, in the case of, say, drug offenses, people can take your car or take your house or take some piece of your property because it's involved in drug crimes. So in the Obama administration, these did spike. They went up. And so part of Michelle Alexander's point is that the war on drugs is something that is not peculiar to any particular political administration. And you don't necessarily have to have a bunch of racist goons running your government in order for it to happen. It's just the way things are done. It's so baked into the system right now that it goes on without much comment with regard to explicit racial bias. Racial bias exists without the appearance of it existing. Okay, so there's much more to the book, and I hope you read the thing in its entirety. It is a good book. despite the fact that it is controversial and does come across as kind of conspiratorial in some places. But please read it in its entirety. These are just but a few highlights that I think are of major importance. And okay, well, that's it for now. Until next time, bye-bye.